Pathfinder Retirement, Vanilla Trust Process, and FYI's webinar. Vanilla. Step by step, where to find and begin filling out your trust. Go to app.justvanilla.com/account/login to log into your account. We do the onboarding process for you. Enter your credentials and click the Log In button. You will then receive a multi-factor code to your phone via text message. Please input this code and then click on the Next button. On your dashboard, you will see a section called Your Tasks. Scroll down the page until you see Vanilla Document Builder, Estate Documents. Once you have found the Estate Documents box, please click on the Create Documents button within that box. Here is where you will scroll down to find all of the different estate document packages. Once you see the option for Basic Trust Package, that is the one you are most likely going to need. Click on the Start Now button within that box. There is an advanced package that includes more for the revocable trust if that meets your needs. You will now be brought to the screen where you will begin the questionnaire for your estate documents. Click on the blue Begin Questionnaire button. A pop-up screen will appear detailing what kind of people are eligible for this kind of trust. Click the I acknowledge box and then proceed to the next button. Vanilla. Step by step, how to fill out the basic info section of your trust. The first page introduces you to the first section of the trust, which is Basic Information. Let's start with some basic information about you and your family. This is a self-paced questionnaire, and we encourage you to take breaks whenever you want to. Your answers are auto-saved, so you'll be able to pick up right where you left off. Please keep in mind that this questionnaire is dynamic, so upcoming questions are based on your answers. Changing your answers after completing a section or after completing the entire questionnaire may result in having to redo it entirely. Proceed to the blue Continue button at the bottom. Here you will input your full legal name, date of birth, and phone number. Don't forget that each page has a Need help with this question? Button. FAQ. What if I go by a name other than my legal name? Do I have to use my legal name in my documents? You should use your legal name when creating estate planning documents. Click the Continue button. Here it will ask you what your relationship status is. You can choose between legally married, divorced, widowed, engaged, or single. Note that only those who select legally married will be asked questions regarding their spouse. For any other selection, you'll be treated as an unmarried individual. FAQs. Why is my relationship status important? Your legal marital status significantly affects your estate plan. It's common for spouses to leave each other the bulk of their estate. This way, the surviving spouse can maintain their accustomed lifestyle. Spouses can also make unlimited tax-free gifts to each other. In most states, you can't disinherit your spouse, and if you attempt to, your spouse has a right to a certain portion of your estate. How does Vanilla Document Builder work if I'm engaged? You should review your estate plan anytime you experience a major life event. This includes getting engaged or getting married. If you are engaged and plan on creating documents prior to you getting married, you should select Engaged as your marital status. This will allow you to complete the questionnaire as an individual, as you are not technically legally married. Then click the Continue button. Here it will ask for your spouse's basic information. FAQ. Why are you asking about my spouse? Marital status impacts the various aspects of an estate plan, including taxation and distribution. Then click on Continue. Here it will ask you where you and your spouse live. Enter the address of what's called your domicile, your true and permanent home. Generally, this is simply the house you live in. If you have multiple homes in multiple states, this is the home you spend the majority of your time in. A person's domicile is usually the same as their current state of residence, but not always. For example, a person may temporarily reside in a different state for school or work. As such, answering this question as accurately as possible is an important step in building your estate plan. The laws governing the interpretation and validity of estate planning documents vary from state to state, and the laws of the state where you are domiciled govern your estate plan when you die. If you change your domicile in the future, you may need to update your estate planning documents. If you are creating documents for a state other than your domicile, you should consult with an attorney before proceeding. FAQs. Will my documents be valid if I move? While your legal documents will still be valid if you move to a new state, it's best to update them to reflect the laws of your new state. Differences in state laws can have a significant impact on your estate planning documents, and powers of attorney may not be recognized if they are not specific to the relevant statutes of your new state. Input your address and then scroll down to the bottom to click Continue. Here, you will add all of your children's basic information and how they are related to you and your spouse. FAQ. What if I have children with someone other than my spouse? If you have children with someone other than with your spouse, you will still add them as part of your family when going through the questionnaire. They would be included in the definition of your children or descendants within your estate plan. Your spouse can add the children or descendants they want to include in their documents. This is important to consider when determining how to structure your plan. Keep in mind, you will have the option to leave unequal or different amounts to your children. Note, if you live in a community property state and you have children from different relationships and wish to only include your children in your plan, you should select the individual trust structure rather than a joint trust. Vanilla Document Builder includes all children listed for both spouses, regardless of parentage in a joint trust. What if I don't want to include some or all of my children in my estate plan? Although it's possible to disinherit a child or a descendant, we don't currently offer that capability in Vanilla Document Builder. If you wish to disinherit a child or descendant, we suggest you work with an attorney directly on your estate planning documents. What if I want to include someone in my plan who isn't legally my child? If you want to include someone in your plan who is not legally your child or descendant, you have two options. One, you may give them a specific cash gift, or two, if you want them to share with your children and descendants. When you are asked if you want your children to inherit all of your assets, you would choose no. You will be given the opportunity to name those who will inherit your assets, and you can choose Add a New Person from the drop-down choices. What if my spouse has children from another relationship? Your estate planning documents include only your biological and adopted children unless you provide otherwise. If your spouse has children or more remote descendants from another relationship, those descendants are not included in your documents unless you specifically choose to include them. However, all of your spouse's descendants will be included in your spouse's estate planning documents. So any property that you leave to your spouse could ultimately pass to those descendants if you die before your spouse. What would happen if I were to outlive my children? If your child predeceases you, any gift that would have gone to that child will either go to that child's descendants, if any, in equal shares, or, depending on your wishes, will be divided proportionately among your other beneficiaries. What if my spouse has children and I haven't adopted them, or vice versa? You should be clear in your desires for how you want to treat your spouse's children, whether you want to include them as a beneficiary in your estate or not. These desires will need to be explicitly stated in your estate planning documents. If you choose to adopt your spouse's children in the future, you should review your documents to make sure that they align with your wishes at that point. What's a descendant? Vanilla Document Builder specifies that the definition of descendant is defined by laws of the state that govern your documents. However, generally, the term descendants mean your children, grandchildren, and great-grandchildren, including an adopted person if such person was legally adopted prior to attaining the age of 18. Then scroll down and click the Continue button. Here you can add anyone else that you would like to include in your estate plan. Consider beneficiaries, gift recipients, and those who will have fiduciary roles, such as powers of attorney, guardians to minor children, trustees, or personal representatives. This will help you plan ahead and assign responsibilities in an organized way. You can always add more people as you go. FAQs. Who counts as family? Your estate plan can include anyone who is important to you and who you consider to be a part of your family. This may be not only your spouse and children, but other family members such as your parents and siblings, extended family, and other loved ones. These are people who will play a part in your estate plan. People you'll either assign fiduciary duties to, e.g., a trustee or guardian of your children, or plan to leave some of your assets to. This can include anyone in your life, for example, parents, siblings, friends, and other relatives like aunts, uncles, or cousins. Do I need to add all of my family members? Let's say you're an only child with 7 cousins, but are only close with your youngest cousin, Laura, and want to name her in your estate plan. You would include Laura, but do not need to add the other 6 cousins who won't be playing a role in your plan. Once all people are added, click Continue. This is the pop-up for the people you are adding to your estate plan. It asks for their full legal name and birth date. Drop-down section for their address is optional. Click Save. Here it will ask if either you or your spouse own any foreign assets. Foreign assets are anything owned in a non-U.S. jurisdiction, e.g., a vacation home in another country. Vanilla's documents are meant to be applicable to assets owned in U.S. jurisdictions only. These documents are not meant to control, alter, revoke, or amend any estate plan executed pursuant to the law of any foreign jurisdiction governing the disposition of such property. Nor does Vanilla guarantee the validity of its documents with regard to the disposition of such foreign assets, and the disposition of such assets will not be specifically included in these documents. By selecting Continue, you acknowledge that you understand and accept the limitations and risks in using Vanilla's documents with respect to assets owned in a non-U.S. jurisdiction. You may wish to consult an attorney. FAQ. What constitutes a foreign asset? Foreign assets include any property, including real property or interest in a business, held outside of the U.S. by a U.S. citizen or resident. Documents created with Vanilla Document Builder will not take any foreign assets into account. If you want foreign assets taken into account in your estate plan, please consult a lawyer. Once your choice is selected, click Continue. Here it will ask if either you or your spouse have any relevant marital agreements. These agreements can include but aren't limited to prenuptial, postnuptial, separation, and divorce agreements. Documents provided by Vanilla do not contemplate the existence of any marital agreement, including but not limited to prenuptial, postnuptial, separation, or divorce agreements. As such, Vanilla does not guarantee, warrant, or verify the appropriateness or applicability of a particular Vanilla document in relation to any existing marital agreement. If you and or your spouse have an existing marital agreement of any type, Care should be taken to ensure that your estate planning documents are in compliance with said agreement. By selecting Continue, you acknowledge that you understand and accept the limitations and risks in using Vanilla's documents with respect to any and all existing or future marital agreements. You may wish to consult an attorney. FAQ. What is a marital agreement? Do I have to create documents with my spouse? A marital agreement typically comes in two variations. 1. A prenuptial agreement, or 2. A postnuptial agreement. A prenuptial agreement, prenup, is negotiated before marriage and clarifies each spouse's interest in property owned before, during, and potentially after the marriage. A postnuptial agreement, postnup, is negotiated after a marriage and clarifies each spouse's interest in property owned during and after the marriage. Note, there are other types of marital agreements that deal and relate to the dissolution of a marriage, such as separation agreement or divorce agreement. These are negotiated as part of those proceedings and specify the property interests and rights of each spouse at that time. Once your choice is selected, press Continue. Here it will simply ask who you are creating the documents for, this being just you or you and your spouse. FAQs. If I'm married, do I have to create documents with my spouse? You may wish to create an individual estate plan independent of your spouse. However, in most cases, it is advisable to coordinate your estate planning with that of your spouse. Once selected, press Continue. Here you will see what types of trust are available to you. Differs by certain states. FAQs. What is community property and how does it affect my estate plan? In community property states, spouses are considered joint owners of nearly all assets and debts acquired in marriage. E.g., even if you took out a loan only in your name, you and your spouse are both equally responsible for the debt incurred. What states are considered community property states? Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. These states allow joint trusts. All other states will have to opt into 2 individual revocable trusts. Should I leave my assets in trust or outright to my spouse? Trusts not only provide your spouse with creditor protection, but they also let you keep control over the remainder of the trust that exists at your spouse's death. Trusts may also help you to maximize the benefit of your tax exemptions. However, it is important to ensure that the trust qualifies for the unlimited marital deduction between spouses to avoid unintended estate tax implications. Select the option you want or what's available to you and press Continue. You will now see an overview of all of your family's basic information as well as your family tree. You've completed the first section. If you need to make edits, select the Basic Information section in the menu on the left. In order to make edits, you'll need to go through this entire section of the questionnaire. Please keep in mind that this questionnaire is dynamic, so questions in upcoming sections are based on the answers you see here. Changing your answers after completing a section or after completing the entire questionnaire may result in having to redo it entirely. Scroll down, making sure everything is correct as you go. Once everything has been reviewed and looks good, you may click on the Continue to Next Section button. Vanilla. Step by step, how to fill out the distribution of your estate section of your trust. Here you will see the page that introduces you to the second section of the trust, the distribution of your estate. In this section, you'll choose how, when, and to whom your estate is divided. Click the Continue button. On this page, it will ask you if you are wanting to restate an existing individual revocable trust. If you select yes, your restated trust will amend all provisions of your prior trust agreement. This means that your prior trust name and date do not change, but all provisions are updated and amended. By continuing to restate your old trust instead of creating a new trust, you will not have to transfer assets funded in your old trust to your new trust. You will continue to fund your trust as you have previously. If you intend to create a new trust and don't want to restate a prior trust, select No. FAQs: What will happen to my current revocable trust? Your new trust will replace your old trust, meaning that your trust will be void or obsolete. As a reminder, you can amend and or revoke your revocable trust at any time prior to your death. I have one or more irrevocable trusts. Will my new documents affect those? The documents you are creating with Vanilla Document Builder will have no impact on your current irrevocable trusts. Select yes or no and then click Continue. Here it will ask your spouse the same question. Select an option and click Continue. On this page, it will ask you if you are wanting to leave any specific cash gifts to individuals or charities. Gifts of a specific dollar amount, often called specific cash gifts, are typically nominal but can be larger if you'd like. These gifts are distributed before estate tax is applied and before the distribution of your residuary estate, which is typically the largest portion of your estate. Care should be taken in considering the amount and number of these gifts to ensure that proper division of your estate occurs. Note that specific gifts are not intended to dispose of tangible personal property. We will include a tangible personal property memorandum, TPP memo, template in your printed documents package, or you can create your own list. FAQs: What's an example of a specific cash gift? An example of a typical specific cash gift would be $5,000 to your nephew or $10,000 to your best friend. How do I gift someone a specific item, like a family heirloom? If you'd like to make gifts of specific personal property, e.g. jewelry, automobiles, art, etc., you'll need to specify these on the Tangible Personal Property Memorandum that will be provided to you to fill out in the physical package that Vanilla mails to you. Is there a limit on the dollar amount I can leave as a specific cash gift? You are only limited by the amount of assets passing via your revocable trust and accounting for any costs of administration and payment of death taxes. Are specific cash gifts made during my lifetime or after I die? Your trust agreement instructs the trustees how to make distributions or gifts after you die. Gifts that you wish to make during your lifetime should be made through other means. What is a specific cash gift? Gifts of a specific dollar amount, often called specific cash gifts, are gifts made to loved ones and charities. They're distributed before the rest of your estate. Note that when you make specific cash gifts, you reduce the amount of your residuary estate and the amount that is ultimately given to your beneficiaries. Are specific cash gifts taxed? In general, specific cash gifts are made before the distribution of the residue, but after the payment of costs of administration and taxes. Any tax associated with such a gift is generally attributed to the estate's residue, the amount remaining after specific gifts have been made. There are a few states that require the payment of an inheritance tax on the distribution. These states require that the beneficiary pay the tax on the distribution they receive. The states that require inheritance tax as of 2024 are Iowa, Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. What's the difference between a specific cash gift and tangible personal property? You may fill out this document to leave your instructions about how specific personal property, e.g., jewelry, furniture, art, etc., should be distributed to specific people. You may also create your own document, note, or letter to specify items you wish to leave to specific people. You can update these instructions at any time, and they do not require any formal execution or notarization. Search the IRS database, linked below, to confirm the legal name of any charity to which you wish to leave a gift. Make sure to use the charity's full legal name. Keep in mind that not all jurisdictions consider these documents to be part of your will or trust. Therefore, they may not be legally binding. Select an option and click Continue. Here it will ask your spouse the same question. Select an option and press Continue. On this page, it will ask both you and your spouse how all of your assets should be passed to one another when one of you passes away. For documents created in Vanilla Document Builder, everything passes to the surviving spouse when the first spouse dies. Go ahead and scroll down. Your options are either outright or marital trust. FAQs. What is a marital trust? A marital trust is a type of trust that allows you to transfer assets to a surviving spouse while controlling how much and when your spouse has access to the trust funds. In addition, a marital trust allows you to dictate who the ultimate beneficiaries of the trust are. Depending on structure, estate tax on a marital trust may be deferred until after your spouse dies. What trust structure is right for my family? Vanilla Document Builder lets you choose from several trust structures for both surviving spouses and descendants or other chosen beneficiaries. Does Vanilla's trust package support the Qualified Terminable Interest Property (QTIP) election for spouses? Vanilla's trust packages allow users to leave assets to their spouse outright or in a marital trust, and the marital trust selection is designed to qualify for the QTIP election. Select an option and press Continue. On this page, it will ask you and your spouse if, after you both pass away, if your children should inherit all of your assets. If yes, your children will be the only beneficiaries included as part of your plan. Note that this doesn't affect recipients of specific cash gifts, since those gifts are made before inheritance. If no, you will be able to name specific beneficiaries in the next questions. These selections may include your children and additional people or charities. Vanilla Document Builder does not currently enable you to properly disinherit a child, and Vanilla does not recommend that the product be used for this purpose. Disinheriting a child in your estate plan requires specific provisions that vary state by state, and Vanilla Document Builder does not have the capability to include these provisions in your documents. If you wish to create an estate plan that disinherits your biological or adopted child, please choose Vanilla's attorney engagement option if available in your state, or speak to an attorney. How do I choose who to leave my assets to? Typically, individuals choose to benefit their family, friends, or organizations and causes they care about. If you have questions or concerns about who you want to leave your assets to, you should consult with your financial advisor or an attorney regarding your post-death wishes and how best to create estate planning documents for those wishes. What if I want to leave assets to other members of my family, e.g. siblings, nieces, nephews, grandchildren, or close friends, as well as my spouse and/or children? This is typically done through specific gifting. Specific gifts are made before your estate is distributed to your beneficiaries, so it's important to be mindful of the amounts given, as these gifts will reduce the amount available for your other beneficiaries. I want to leave certain items to certain people, e.g., great-grandma's engagement ring to my daughter. How do I do that? A Tangible Personal Property Memorandum Template, TPP Memo, will be included in your printed documents package. Select an option and then scroll down to click Continue. This page asks you how you would like your assets to be distributed to your children. Your options are outright or in a trust. Outright. All of your trust assets will be distributed directly to your beneficiaries outright. They will take full control of the estate and have the ability to change beneficiaries and distribute assets as they please during their life and at their death. In a trust. All of your trust assets will be held in one or more irrevocable trusts for the benefit of your beneficiaries. The terms of your trust will control timing and level of access your beneficiaries have to the trust or trusts. After the death of your beneficiaries, the remaining trust assets will go to your designated beneficiaries based on the terms in your trust. FAQs. Which trust is right for my beneficiaries? Vanilla Document Builder lets you choose from several trust structures for both surviving spouses and descendants or other chosen beneficiaries. Should I leave my assets in a trust or outright to my children? By placing assets in a trust, you can provide your children with access to the assets while also protecting and preserving them for future generations. Not only do they provide your children with creditor protection, but trusts allow you to control when and how your assets will be received by your children and potentially their children. Trusts may also allow you to maximize the benefit of your tax exemptions. Make a selection, scroll down, and press Continue. Here it will ask you how you would like to divide your assets amongst your children. Scroll down to Review Options. You may choose one of three options. There is Perpetual Pot Trust, Separate Trusts, Equal Shares, or Separate Trusts. Unequal Shares. Perpetual Pot Trust. A single irrevocable trust for the benefit of all beneficiaries. Distributions can be made at the trustee's discretion to any one or more of them. Distributions depend on the needs of the beneficiary, and there is no requirement that the distributions are equal among beneficiaries. The pot trust may be divided into separate individual trusts for each beneficiary later on, and will last until all named beneficiaries are deceased or sooner if state law requires. Separate trusts, equal shares. Your trust assets will be divided into equal shares for your beneficiaries. Each beneficiary will receive the same amount of assets to be held in trust or distributed outright to the beneficiary. Separate trusts, unequal shares. Your trust assets will be divided into unequal shares for your beneficiaries based on percentages you select. You will choose the percentage to be distributed to each beneficiary and how the beneficiary will receive their distribution, whether outright or in trust. Once an option is selected, please click Continue. Here you will see two options to choose from. Regarding whether you would like to add a specific age your beneficiaries can receive their trust assets at, or if it will be through their lifetime. If yes, your children will have access to their funds at an age or ages that you'll choose in the next question. If you choose the no option, assets will remain in the trust for each child's lifetime. The trustee that you designate will have the ability to make distributions for qualified purposes, including health, education, maintenance, and support. Note that you'll have the option to allow your children to become their own co-trustee and or remove a trustee at a given age in the next questions. Will my beneficiaries be able to withdraw money from their trust when they reach the age I specify? There is an important distinction between a withdrawal right and mandatory distribution at a certain age. A withdrawal right means that a beneficiary has the right, but not the obligation to withdraw money from the trust at a certain age. On the other hand, a mandatory distribution at a certain age means that the beneficiary will receive the specified amount of the distribution once they attain that age. Note that if you wish for your beneficiaries to receive their trust assets at a certain age, these will be mandatory distributions, not withdrawal rights. Should I give my beneficiaries everything at once or distribute it over time? What age should I allow my beneficiaries access to money from their trust? For younger beneficiaries, it's typical to allow them to serve as a co-trustee of their own trust around age 30, then give them the ability to remove their co-trustee around age 40. This permits the beneficiary to serve as the sole trustee of their trust. Once chosen, press the Continue button. This page asks at what age would you like your beneficiaries to be to receive full access to their individual trust assets. If you've chosen to divide distributions over 10 years, enter the age you'll want your beneficiaries to receive their final distribution. If you've chosen everything at once, this is the age they'll receive all of their assets. If you've chosen divided over 10 years, your beneficiaries will receive 3 distributions. Year 1, 1/3 of the total amount in the trust. Year 5, half of what's remaining in the trust. Year 10, the age entered above. The rest of the assets left in the trust. Once selected, click Continue. It then asks how you would like to structure your distributions, your options being either everything at once or divided over 10 years. If everything at once is chosen, your beneficiaries will receive all of their trust assets at the age you specify. Once selected, press Continue. This page shows a summary overview of your distribution of your estate. Scroll down to review your selections. Once you have reviewed everything and it all looks correct, go ahead and click on the Continue to Next Section button. Vanilla, step-by-step, how to fill out the Fiduciaries and Healthcare Wishes section of your trust. Here is the first page of Section 3, Fiduciaries and Healthcare Wishes. A fiduciary is a person who is responsible for carrying out your wishes, making important decisions, and playing important roles in your estate when you are unable to act on your own behalf, including after your death. Click on the Continue button. This page allows you to pick who you would like to appoint as guardians to your minor children. A guardian is the person who steps in if both parents can no longer take care of their children. Your children's guardian is named in your pour-over will. Should you ever be unable to, this person will be responsible for taking care of your minor children. Your children's other parent will automatically be named their primary guardian, so no need to name them here. Here, you're identifying who will take care of your children if both parents are unable to do so. FAQs: which document are guardians named in? Guardians are named in your pour-over will. How many guardians should I name in my pour-over will? Typically, people name one primary guardian and one backup. If you're married and have children with your spouse is automatically named as the primary guardian, so you should identify the person who would act as guardian if your spouse were unavailable to serve. Why can't I name 2 people to serve together? Designating a specific individual as guardian is best practice to avoid ambiguity. Naming one person prevents confusion about your intentions, especially in unforeseen circumstances, e.g., divorce, about who should be legally responsible for your child. What if I want a couple to be the guardians? Consider who you would trust most to take on this responsibility. Name that person as the primary guardian and the other as the secondary, ensuring there's a clear plan in place. Are there any rules or restrictions on who I name? Generally, any guardians you name must be 18 or older. Once added, scroll down and press the Continue button. Here it will ask you who you would like to appoint as your personal representative. A personal representative, also called an executor, manages your estate after you die, making sure everything gets done correctly. If you're married, include your spouse below if you wish for them to serve as your primary personal representative. Your personal representative is named in your pour-over will. Being someone's personal representative is a significant responsibility and requires a lot of time and effort. This person essentially handles all the necessary tasks after you die. They will take care of settling your debts, ensure that any taxes owed are paid, and ultimately distribute your assets to the appropriate beneficiaries. FAQs: How many personal representatives should I name? Typically, people name one primary personal representative and one backup, with married couples often naming each other as the primary personal representative. Should my spouse and I name the same people as personal representatives in each of our documents? Spouses do typically name the same people to serve as personal representatives in each of their planning documents. It's not required, though. Is a personal representative the same thing as an executor? A personal representative is the person you name in your pour-over will to oversee the administration of your non-trust assets. This person is charged with satisfying any debts of the estate, paying any taxes due, and then distributing any probate assets to your trust. Once added, scroll down and press the Continue button. On this page, it asks your spouse the same question. Once added, scroll down and press Continue. Here it will ask you who you would like to appoint as your successor trustee. You'll be responsible for managing your trust during your lifetime. Your trustee is responsible for managing your trust according to your instructions after your death. If you're married, include your spouse below if you wish for them to serve as your primary successor trustee. Trustees hold legal title to and administer property in a trust arrangement. Trustees are fiduciaries with a legal duty to carry out the terms of your trust. This means that they have to act in your and your beneficiaries' best interests and manage any trust assets prudently based on the requirements laid out in the trust document. You must add a successor trustee. You can also add a backup. Roles can be switched by selecting the role label. FAQs: How many successor trustees should I name? Typically, people name 2 successor trustees, with married couples often naming each other as the first successor trustee. Who should I name as my successor trustee? You can name any individual you want. Just remember that it's important to name someone who you trust and who has sufficient knowledge and time to be able to carry out the duties of the trustee. What if my successor trustee dies? The terms of your trust will control trustee succession in the event of death or incapacity. Vanilla Document Builder gives you the option of adding multiple successor trustees, so if you're concerned about a trustee passing away, you should name a second successor. What are the responsibilities of a trustee? A trustee manages the trust property in accordance with the instructions you leave them. Examples of a trustee's responsibilities include facilitating and collecting insurance benefits, maintaining accurate accountings and records, paying bills and expenses, filing tax returns, investment management, and distributing assets to your beneficiaries as directed in your trust. Once elected, scroll down and click Continue. Here it will ask your spouse the same question. Once elected, scroll down and press Continue. On this page, it asks you who you would like to appoint as your financial agent. Your financial agent acts on your behalf, managing your finances and making important decisions when you're unable to do so yourself. If you're married, include your spouse below if you wish for them to serve as your primary agent. Your financial agent is named in your power of attorney document. This role takes effect while you're still living. Typically, your agent can act on your behalf to manage your financial affairs, including banking, investments, real estate transactions, and taxes. Your financial agent is legally bound to act in your best interests. After you die, your agent's power ends, and they can no longer make financial decisions on your behalf. FAQs. How many financial agents should I name in my power of attorney document? Typically, people name one primary agent and one backup, with married couples often naming each other as the primary fiduciary. Should my spouse and I name the same people as financial agents in each of our documents? Spouses do typically name the same people to serve as financial agents in each of their planning. It's not required, though. What if my financial agent dies? You can name successor agents in your power of attorney document in the case of death or incapacity of your primary agent. Here it will ask your spouse the same question. Once elected, scroll down and click on Continue. Next, it will ask you who you would like to appoint as your healthcare agent. You must add a primary healthcare agent. You can also add a backup. If you're married, include your spouse if you wish for them to serve as your primary agent. Healthcare agents are appointed to make healthcare decisions for you when you are unable to make such decisions for yourself. In addition, a healthcare agent is often granted access to your healthcare information and is allowed to communicate freely with your healthcare providers. FAQs. What does a healthcare agent do? Is it the same as a durable power of attorney? A durable power of attorney is a document that authorizes a person, the agent, to make healthcare decisions on your behalf. How many healthcare agents should I name in my Advanced Healthcare Directive document? Typically, people name one primary agent and one backup, with married couples often naming each other as the primary fiduciary. Should my spouse and I name the same people as healthcare agents in each of our documents? Spouses do typically name the same people to serve as healthcare agents in each of their planning documents. Does my healthcare agent need anything from me? At the very least, your agent will need a copy of your healthcare power of attorney document. If you have a separate living will, physician orders for life-sustaining treatment, POLST, HIPAA waiver, or any other relevant healthcare-related documents, they may need copies of those as well. Can I leave specific instructions to my healthcare agent? Vanilla Document Builder's healthcare documents allow you to make several choices related to your end-of-life care, including pain management and medication. Note that you'll be making these choices on the actual printed documents that we mail to you and not in this questionnaire. If there are specific wishes you have with regard to your care, you should communicate those to your healthcare agent. It is best to do this in writing, e.g., a letter. What if my healthcare agent dies? You can name successor agents in your durable power of attorney document for use in the event of death or incapacity of your primary agent. Once elected, scroll down and click on Continue. Here it will ask your spouse the same question. Once elected, scroll down and click Continue. On this page is the section summary for your fiduciaries and healthcare wishes. This section is complete. If you need to make edits, select the section title in the menu on the left. In order to make edits, you'll need to go through this entire section of the questionnaire. First, review your guardian section and make sure everyone listed is correct. You've assigned these individuals to assume responsibility for your minor children, or for any adults in your life who need help taking care of themselves. Once reviewed, scroll down. Secondly, review your personal representatives section and make sure everyone listed is correct. You've assigned these individuals to administer and settle your estate after your death according to the terms of your will. Personal representatives are often referred to as executors or administrators of your estate. Then scroll down. Third, review your trustees section and make sure everyone listed is correct. You've assigned these individuals to the legal title to administer property in your trust arrangement. They will have a legal duty to carry out the terms of your trust, which means that they'll have to act in your and your beneficiaries' best interests, managing any trust assets prudently based on the requirements laid out in your trust document. Then scroll down again. Fourth, review your financial agent section and make sure everyone listed is correct. You've named these individuals in your durable power of attorney. They're granted specific powers related to your finances and property should you become incapacitated. Scroll down again. Lastly, review your healthcare agent section and make sure everyone listed is correct. You've named these individuals in your healthcare power of attorney. They make healthcare decisions for you when you're unable to make them yourself. They're also granted access to your healthcare information and are allowed to communicate freely with your providers. Once everything looks correct, click on the Continue to Next Section button. Vanilla. Step by step. Review and approve section of your trust. Once you have arrived at Section 4, Review and Approve. Under the Your Answers tab, double-check all of the drop-downs for each section. The first section to review will be your basic information section. Ensure that your family tree looks correct. Scroll down to the next section. Double-check your children's birth dates and how they are affiliated with you and your spouse. Make sure your address, marital agreements, and foreign assets are correct. Scroll down to the next section. There will be an Edit Basic Info button if you need to go back and change anything from the section that was not correct. If not needed, click on the drop-down for the distribution of your estate. Ensure all information shown for this section is reviewed and correct. Continue to scroll down. Continue to review questions and answers for this section. Continue to scroll down. If you need to fix something, click on the Edit Distribution of Your Estate button. If not necessary, then click on the drop-down for your Fiduciaries and Health Care Wishes section review. Please start by reviewing your Guardians section, then move down to your Personal Representatives section. Next, review your Trustees section. Once reviewed, move on to your Financial Agents section. Here you can review your financial agents and healthcare agents elections. Continue to scroll down. If needed, click on the Edit Fiduciaries and Healthcare Wishes button. If everything looks correct, go ahead and click on the Yes, Review My Documents button. Here you will see what documents you, and if applicable, your spouse, will be receiving for your trust. This includes the type of trust you and your spouse elected for, as well as a certificate of trust. You will see that you and your spouse both have documents for a pour-over will, state-specific financial POA, healthcare POA, and HIPAA release forms. Once done, scroll down and click Yes, Finalize My Documents. Congrats on your new trust documents! If you need any further help filling out your trust, please don't hesitate to reach out. You can call me at 719-200-5877 or email me at jonathan@pathfinderretirement.com. I'd be happy to arrange a convenient time to help you. Thank you.